All right, let's talk a little bit about SCOTUS and what they were contemplating with regard to January 6th.
Yeah, so absolutely. We can go ahead and put this first element up on the screen. This is from Megyn Kelly, who was following the Supreme Court arguments yesterday on this case. Megyn said, big Supreme Court argument on whether, quote, obstructing an official proceeding can form the basis for a criminal charge versus J6 defendants, including Trump. This is the heart of Smith's J6 case versus him, is not going well for the government at all. All 6 conservatives sound like they're on the side of the defense. If they side with the defense here, it guts Jack Smith's D.C. case against Donald Trump. So let's break down a little bit about why that is. There's this tear sheet here from SCOTUS blog. They write, the Supreme Court heard that oral argument in the case of a former police officer from Pennsylvania who entered the Capitol during the January 6, 2021 attacks. Joseph Fisher, who was charged with, among other things, assaulting a police officer, disorderly conduct in the Capitol, and obstruction of a congressional proceeding, has asked the justices to throw out the charge that he obstructed an official proceeding, arguing that the law that he was charged with violating was only intended to apply to evidence tampering. More than 300 other J6 defendants have been charged with violating the law, which, and this is very interesting, was enacted as part of the Sarbanes-Oxley Act in the wake of the Enron scandal. And I guess people can understand why, and then also sort of understand why it's narrowly been interpreted in the past to talk specifically about that question of evidence tampering. SCOTUS blog writes, it's also at the center of 2 of the charges brought by Jack Smith against former President Donald Trump in Washington, D.C. That is the same case in which the justices will hear argument on, guess what, April 25th, so coming right up, right around the corner, regarding Donald Trump's claims of immunity. So Fisher had sent some text messages in which he indicated to acquaintances, SCOTUS blog writes, that members of Congress can't vote if they can't breathe, ... LOL, and that he might need his police chief to post my bail. It might get violent. On January 6th, prosecutors say Fisher urged rioters to charge and hold the line. In a message on social media on January 7th, Fisher wrote that he had been pepperballed and pepper sprayed, but entry into the Capitol was needed to send a message that we the people hold the real power. So the reason it's important to note those quotes is because you can see that Fisher saw, according to these messages at least, his entrance into the Capitol, his sort of violent entrance into the Capitol as an intentional act of obstruction of the proceeding of certifying the electors. So that's the, I think, relevant context in that case. But if the statute can be interpreted as something that goes beyond evidence tampering, is actually at the heart of the question. It's sort of like what we were talking about in the last block, Krystal, like 2 things can be true. It can be true that he clearly intended to obstruct the proceeding without this charge specifically being applicable, this post-Enron charge specifically being implicable. I believe SCOTUS blog actually has in this article, I'll find the exact quote, that it's true this hasn't been interpreted in the past. There's not precedent for interpreting this to go beyond that narrow question of evidence tampering. And if the justices come down in June, July with a ruling here that you can't have evidence tampering, that you can't go beyond evidence tampering, that's pretty devastating to the case.
Yeah, so you had one judge in the context of, this case making its way up to the Supreme Court, acknowledging that outside of the January 6 cases brought in this jurisdiction, there is no precedent for using the obstruction provision to prosecute the type of conduct at issue in this case. To be honest with you, maybe this will surprise you, I didn't think that the government had good answers to this question of, okay, well, how do you get this? Where's the limiting principle? So if you have protesters who pull a fire alarm during a congressional vote, does that count? Can you get thrown in prison for that? Now, in reality, none of the January 6 protesters who were charged with this, it wasn't the only charge they were faced with. So in other words, if you just had someone who, trespassed and wasn't hit with any other charges, there was no one who this is the only thing. It was used as a way to sort of up the ante in terms of what sort of sentences the government could obtain here. In the language, first of all, you do have the context of this was about Enron and Sarbanes-Oxley and all of that. And the language is very vague. and honestly makes me pretty uncomfortable. It says impede. One of the words is if you impede a government proceeding. So again, what's the limiting principle there, and how do you make sure that in applying this law, you are not taking a sledgehammer to other, protected speech and other sort of protest activities that any of us could easily imagine? You even had Ketanji Brown Jackson in these arguments expressing reservations about what the government was arguing here. She said the court should not lose sight of, quote, the backdrop of a real world context, which I think is what I'm speaking to here. And Emily, I think we have some of the clips of some of the conservative justices asking these critical questions.
Yeah, let's go ahead and roll that. You can hear conservative justices Amy Coney Barrett and Neil Gorsuch poking some serious holes in the government's case.
What does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
What if on January 6th, the Capitol itself had not been breached? The protest is going on outside the Capitol. Stop the steal, stop the steal. Police are, in megaphones saying disperse, disperse. They're too close to the Capitol. Their goal is to impede, stop the proceeding, stop the counting of votes. Does that violate the statute in your view under this impede language?
So I think that one relevant question would be whether we could satisfy the nexus requirement and show that actually the natural and probable effect of that conduct would be to have some effect on what's going on in the Capitol and
Yes,
in the
so
mind run.
You can.
Yes. So if you're assuming that the same thing happened where Congress had to go into recess and couldn't hold the joint session after all because there was such a security risk, I think that probably would be chargeable if we had the intent evidence. Now, as I mentioned before, even with respect to the riot that happened, which was a much more serious breach, we don't have that evidence of intent for everyone. But if we had, for example, organizers where it was absolutely clear that they were the ringleaders who had intended to obstruct and undertook the action with that specific intent and did so knowing it was wrongful, and especially if they went, I'm assuming you're saying they're in the unauthorized area right outside the Capitol, that is unlawful conduct committed with consciousness of wrongdoing if we have the proof of it.
Let's say that I am having a hard time accepting your limiting construction of the verbs obstruct, influence, or impedes to have this extra element. Tell me why I shouldn't be concerned about the breadth of the government's reading, just relying on corruptly and the nexus requirement. Should I be concerned, or could you just embrace it and say, yeah, there might be some as applied First Amendment challenges or that sort of thing? I mean, can I be comfortable with the breadth if that's what I think?
Yes, you can be. You certainly don't have to agree with us that a de minimis hindrance wouldn't qualify. If you thought that this was unqualified and swept broadly to any kind of hindrance whatsoever, there would still be really important limits in the statute.
Krystal, can I say that Biden's Solicitor General there sounds very conservative? It actually reminds me of a lot of conservative arguments about protests and speech in the past. Because, this idea that you should curb down on any sort of public disobedience, anything like that, you can just really easily see. It kind of reminds me of what we were talking about in the campus speech block. You can easily see how when you have interpretations like that, they can be applied wildly to just protests in general, because in essence, every protest is trying to, quote unquote, obstruct, maybe not a technical, narrow constitutional proceeding as is in this case, but in a lot of cases, they're trying to obstruct some type of proceeding. There is some type of legislative proceeding that they don't want to happen. So you can see how language like obstruct and proceeding being interpreted in this way could get really, really out of control for government censors or would-be government censors and people who want to crack down on legitimate protest. Yeah,
the language is obstruct, influence, or impede.
So influence.
Right, exactly. That's it. It really is written in this very broad way that I think should make us uncomfortable. And obviously, we referenced that this not only impacts the, I think, hundreds of January 6 defendants who had this as one of the charges that was brought against them, but it does directly impact Donald Trump in terms of the January 6 case, as Megyn Kelly was pointing out. So he was charged. Of course, he's got a whole raft of charges that he's facing, including the hush money situation that he's dealing with in court in Manhattan as we speak. He's got the documents case. He's got the Georgia case. But in terms of the federal January 6 case, he was charged with one count of conspiracy to defraud the United States. That's about his efforts to spread false claims about November 2020 election, knowing they weren't true, attempting to illegally discount legitimate votes, all with the goal of overturning the 2020 election, according to prosecutors. One count of conspiracy to obstruct an official proceeding. That's the one we're talking about here, due to the alleged organized planning by Trump and his allies to disrupt the electoral vote certification in January 2021. Another count of obstruction of an attempt to obstruct an official proceeding, which has to do specifically with those election certification efforts that we've been talking about. And one count of conspiracy against rights, referring to Trump and his co-conspirators allegedly attempting to oppress, threaten, and intimidate people in their right to vote in an election. So you've got 4 different counts there related to January 6th. So if the official proceeding one is out the window, then you're left with 2 counts, this conspiracy to defraud the U.S. and this conspiracy against rights that Jack Smith is left with in terms of the January 6th case. So it is definitely quite consequential in terms of Trump's legal jeopardy in that particular situation that he is in legal jeopardy from.
Not to quote The Bachelor, but to quote The Bachelor, whether or not you believe that the conservative justices are in this for the right reasons. By the way, I hate The Bachelor, but whether or not you think they're in it for the right reasons, I actually hope that they push back on this and they really set precedent to interpret this narrowly, because you could, it already feels like we're sort of lurching ever closer to Banana Republic territory. But, you can see how when Republicans, for example, just in Congress, when they started to push back on, for example, Nancy Pelosi wouldn't seat the members that they wanted on the January 6th committee, or, Republicans or Democrats, impeached Trump for his, quote, perfect phone call to Zelensky. And then Republicans went and started to seriously talk about impeachment for Joe Biden, doing this kind of escalating tit for tat. You could easily see actually how Joe Biden, you have a bunch of liberal activists, progressive activists protesting something like the voting rights legislation in Georgia, and Joe Biden, saying something that aligns with them, trying to influence the official proceeding of the vote on that. This can just get blown up, and you never underestimate the cynical tactics of people in positions of power to wield statutes like this for immediate political ends that do not serve the sort of best interests of the country, that do not set long-term standards in the best interests of the country, and do not serve, frankly, the Constitution and their oath of office. So never underestimate the cynicism of our elected officials, because they will wield these things in ways that
absolutely
bring us closer to the brink.
You want Tom Cotton to a future president, Tom Cotton, or future president Donald Trump, or whoever. You want them to have the power to wield this, to its fullest extent. Not me, right. Personally, not me.
Right.
There was one liberal argument, though, that did land with me about Justice Thomas. I'm curious your thoughts on this. Emily can put this one up on the screen. So this is from Jeffrey Toobin. He says, most credible of sources here. Anyway, put that aside. In oral argument today, Justice Thomas is minimizing the severity of the January 6th insurrection at the Capitol. Perhaps that's because his wife was part of the conspiracy. What a disgrace that he's sitting on this case. I actually do think it's inappropriate for Thomas to be involved in this case. His wife, as you referenced earlier, Emily, was involved in some of the organizing for that day. There were a bunch of infamous, texts between her and then Chief of Staff Mark Meadows about the Stop the Steal conspiracy, in which she was incredibly encouraging, et cetera. And so I do think that it's inappropriate that he's involved here. And it just speaks to, there's any number of cases that he and other justices, by the way, should have recused themselves from if we're upholding a high standards of ethics where even the appearance of a conflict of interest should be enough for you to recuse yourself. But the Supreme Court doesn't have an official code of ethics, which is insane. They're just left to like make their own decisions about whether or not they feel conflicted and feel like they want to recuse. And so Justice Thomas doesn't ever feel like he needs to recuse himself, even from cases that in which he has a direct financial interest. That's always also been an issue in the past.
You know, yeah, so this is interesting because I agree completely that the Supreme Court needs a code of ethics and that conflicts like this are far from ideal. I do think that there's a good argument for there being a conflict of interest in this case. I think that's always been an issue for Clarence Thomas, and I don't think, again, that's ideal. You know, I think it's unfortunate that Ginny Thomas wants to be a conservative activist, and, you know, like she wants to do it for good reasons. Like, she really believes in the cause. So I don't think it's ideal that it creates these conflicts of interest because, you know, I feel for anybody that wants to be involved and advocate on behalf of ideas that they believe in really strongly. But, you know, that's been kind of the problem, is that there is no consistent code of ethics. So Clarence Thomas is like, there's this big effort on the left, and, you know, this could blow up into a huge, like, we could spend a whole show on this, but from my perspective, I think there's been a decades-long effort to discredit Clarence Thomas, specifically because he is a Black sort of conservative jurist, and that he's gotten a lot of racism, frankly, because of all of that. And so that lack of consistency is what has allowed for, I think, some of these conflicts of interest to fester. So I agree. I think it's sort of a problematic conflict, but I think, you know, we talk about it, not us, but I think the media talks about it specifically with Clarence Thomas more than some other justices, but that doesn't make it right. So I ultimately kind of agree. I don't think it's an ideal situation to have the different interests at hand here. I do want to mention another Megyn Kelly tweet, this time at Jeffrey Toobin. In response to that tweet you just read, Krystal, Megyn said, "Hi Toobin, FYI, you waived your right to use the term disgraced about other lawyers when you took your dick out of your pants and jerked off in front of your colleagues. Not safe for work, folks."
Nice. Nice. But his point stands about Clarence Thomas. I mean, I am not going to dispute there's been plenty of racism, you know, directed towards him, especially with regards to, he infamously doesn't really usually chime up during oral arguments, and this was sort of used to smear him as unintelligent. If you read about his actual philosophy, I mean, he's this weird sort of like almost like right-wing Black nationalist. He's very cynical about racial politics. Once I, you know, really learned about his ideology is actually a little different than what I thought. He is just as cynical about the possibility of sort of racial coexistence and reconciliation as like a Nicole Hannah-Jones. I mean, they actually there's a weird horseshoe there in terms of racial pessimism. We'll put that ideology aside for another day. But I think part of that cynicism from him is his willingness to accept like these large monetary gifts and monetary assistance and, you know, the trips and the helping to pay for the RV and his mother's house and all of these things, because first of all, that is completely corrupt, and he is an outlier in terms of how much he appears to have accepted these types of gifts. Not that he's the only one who's done it, but the frequency, the amounts, the unwillingness to disclose, et cetera, I do think is at another level with Clarence Thomas. So in that way, the additional scrutiny of him is very justified. And I think it comes from this deeply cynical place of his view of politics, which is like, yeah, rich people have their way. It's a corrupt system, and I'm part of that corrupt system.
He also has this sort of uniquely inspiring story that I think has been has made him more attractive as sort of a compatriot to that donor class. You know what I mean? The sort of like billionaire donor class that has all of these massive charities that he's used the Supreme Court to have ceremonies at. I think he's just sort of especially attractive to them because he grew up like speaking Gullah dialect in like the most rural place that you could imagine in the United States, and had this like weird, like you said, he was basically in college, he was basically like a left-wing black nationalist, and then had this interesting evolution. There's a good documentary called Clarence Thomas Created Equal that was done by people who are favorable to Thomas, but it's still just him kind of telling his life story, and you get a different glimpse than what the media tells you. But I think basically the bottom line, Krystal, is that we agree the Supreme Court has a big ethics problem on its hand, because, when you have in your family these interests or personally these interests, I think with Ruth Bader